60 stab wounds. That is a real difficult pitch to make as a crime of passion, as a person so caught up in the heat of the moment that they took somebody else's life, somebody that they cared about. The highly anticipated trial of a pharmacist accused of murdering her husband upon his discovery of her fraudulent Ponzi scheme kicks off in West Virginia. Plus, a surprising verdict for a Florida grandmother implicated in the death of her 7-month-old granddaughter. And a Tennessee man stands trial for the stabbing death of his girlfriend after her body was found concealed inside a suitcase. All this and more this week on Courtroom Confidential. A few cases that are new to our channel this week, a lot for us to discuss. We are recording this episode on Thursday, January 16th, 2025. Let's jump right in. First, after years of delays, the trial of a former West Virginia pharmacist who is accused of murdering her husband finally began this week. Natalie Cochran is charged with first-degree murder in the death of her husband of nearly 19 years, Michael Cochran. At the time of Michael's death in 2019, Natalie was running a Ponzi scheme that defrauded investors, including Michael's parents, out of millions of dollars. She pleaded guilty in 2021 to federal wire fraud and other charges and was sentenced to 135 months in prison. Raleigh County Prosecutor Tom Truman says Michael was killed by his wife when he started to ask questions about her Ponzi scheme. The prosecutor argued that Natalie took insulin from a neighbor and gave it to her husband, who later passed out in the kitchen. Did she call 911? No. Did she load him into a car and take him to the ER? No, Truman said. All the opportunities to get help for this man, and she took none of them. Michael would die within the week. For his part, defense attorney Matthew Victor told the jury the prosecution's allegations were far-fetched. Victor argued Michael was up to his eyes in the Ponzi scheme with his wife, and any evidence the prosecution has about insulin being the cause of death would be easily discredited. Quote, he was taking medication, steroids. They were not for human consumption. They were some animal medications taken, Victor said. Michael was a ticking time bomb when it came to his health, according to Victor. Court TV reports that Natalie was originally indicted on murder charges in November of 2021, but those charges were dismissed at the request of prosecutors in April of 2023 because they wanted to exhume Michael's body and conduct further testing. Natalie was indicted again on murder charges in October of 2023. She faces a potential life sentence if she is convicted of murder. What's happening here? The defense has been making a lot of objections regarding evidence of the Ponzi scheme, and their objections are that, listen, she is not charged with fraud in this case. She was charged with fraud. She's been convicted for fraud. She's doing time for fraud, but that's not what she's on trial for here. So any questions regarding the money scheme, the Ponzi scheme, all of that should be irrelevant. Now, he's got a little bit of a point, doesn't he? We don't put people on trial for things that they're not accused of, even if that's bad behavior, even if that's criminal behavior. We don't start bringing up things from the past. We've talked about this many, many times before. It's the idea of bringing in what's called prior bad acts. And for the most part, you are not allowed to do that. For the most part, that is seen as putting someone on trial for their character, which we do not allow in this country. But there are exceptions. One of those exceptions is if you're trying to prove motive, which is interesting because motive, as we've said many, many times before, is not an element that needs to be proven by the prosecution. The prosecution has to prove many things, many different elements, including intent, but they don't have to prove motive. They don't have to prove the why. However, they are allowed to prove motive. They are allowed to present motive evidence if that's important for the jury to understand that this is the person that committed the crime because they have the motive to commit the crime. And you are allowed to bring in prior bad acts if you are bringing them in order to prove motive. So in this case, I think that her Ponzi scheme, the fraud that she was up to, If that was, in fact, according to the prosecution, her motivation for killing her husband, it falls squarely into those exceptions. And it should be something that the judge will allow and is allowing despite the defense objections. But he must make these objections. These are objections that he has to make, regardless of the rulings, regardless even of his understanding of the law. And he knows it. He knows he's going to get these objections overruled, but he's doing them for two reasons. One, that's to preserve them for appeal. Always, defense attorneys have to make sure if they want something to be able to be brought up on appeal, they must object to it and have that overruled by a judge at the trial court level. If there is no objection, many times the courts of appeal will say, well, you waived your objection. You didn't raise this issue. Therefore, there's nothing for us to review upon appeal, because many times on appeal, what the court is doing is simply reviewing the trial court judge's orders, not orders they could have made, not speculation of things that could have gone wrong, but actual orders. And if you don't make the judge make an order, there's nothing for you to appeal. But he's doing it for another very clever reason, and that is he wants the jury to hear it. He wants the jury to hear that he's got a problem with this evidence. He wants the jury to hear that he's objecting to this type of evidence being used against his client when his client is not on trial for those crimes in this case. Will that carry the day? I don't know. Is it an excellent trial strategy? I think absolutely yes. But what do you guys think? Do you think the jury will be improperly tainted by this fraud evidence, or do you think that they can use it properly as it's intended to be as motive evidence? Let us know in the comments. A Florida woman charged for leaving her granddaughter in a hot car was acquitted of the most serious charges in the infant's death. Tracey Nix was charged with aggravated manslaughter in the November 2022 death of Uriel Shock. On Tuesday, a jury found her not guilty of that charge, but convicted her of leaving a child in a motor vehicle in excess of 15 minutes. The day Uriel died, Tracey told a detective that after she drove home from lunch with friends, she, quote, just forgot about the baby in the backseat of her Lexus SUV. It wasn't until after her other daughter and one of her grandsons arrived that all of a sudden it came across her head that Uriel had been in the SUV all afternoon. Temperatures that day reached 90 degrees Fahrenheit. A medical examiner determined Uriel died from hyperthermia as a result of being left in a hot car for several hours. According to Scripps News Tampa, Uriel is the second grandchild to die under Tracey's care. In 2021, a 16-month-old Ezra drowned in a nearby pond after Tracey fell asleep. A judge ruled Ezra's death could not be mentioned during the trial for Uriel's death. Nix faces a potential sentence of up to 8 years in prison when she is sentenced at a hearing on April 3rd. What's happening here? First of all, these cases are just incredible tragedies, and they're very difficult for prosecutors to handle. Even the mother of the child in this case was torn. This is her own child whose life was lost, and then her own mother who's on trial for her responsibility in connection to that death. It's very difficult. It's a lot of treacherous waters for a prosecutor to walk through with the right kind of emotion and balance to present this to a jury. I think a mistake was made here, however, by the judge. The judge didn't allow the jury to hear about the previous death of a child under Tracey's care. Now, there's two ways to think about this. If the judge were to allow evidence regarding that prior death with such similar circumstances, in a case like this, with such a high emotional charge involved in it, you could understand how a jury might be more prejudiced by that evidence than finding it probative. And this is what I mean by that. Juries tend to look, like we all do, at things like patterns and say, what are the chances of something like this happening more than once? Well, if that prior incident, as similar as it was simply an accident, then it really doesn't have relevance to what we're talking about in this case here. Even though it is so similar, you could understand how a jury would simply view it as too much of a coincidence and convict her, not based upon the evidence in this case and the death of this current child, but based upon the pattern, based upon the coincidence. And that would be inappropriate. And so therefore, a judge has to balance always the prejudicial versus the probative value of evidence. The evidence may be useful, but is it more prejudicial to the defendant than it is actually useful to the prosecution? Always a balancing must be made there. But sometimes the pattern is the evidence. Here, her absent-mindedness is on trial. It's her gross negligence. It's her criminal negligence that's on trial. And isn't that demonstrated by past conduct? It, I believe, would be unfair to say that this was an anomaly in this woman's life, that this was simply one instance that was tragic and horrible and something that anyone would want to avoid. But she shouldn't certainly be held criminally responsible for that when we know, in fact, according to the reality of the universe, that is not true. It is not an anomaly. And in fact, it is a repeated pattern, if you want to call it that. There was a prior instance where her negligence led to, arguably, the death of another child. And even though I think a jury could draw conclusions that what are the chances, I think it is probative to the jury to understand that this person, this defendant, has a problem with their negligent care of children. Like I said to begin with, difficult cases, horrible, horrible accidents do happen. People can be absent-minded and also not be criminal. But in a case where someone has demonstrated that same type of negligent, absent-minded behavior, is it no longer an accident and does it step into the realm of criminal behavior? I don't know, but what do you guys think? Do you think the judge made a mistake by not allowing that previous evidence in? Please let us know in the comments. Trial began this week for a Tennessee man charged with first-degree murder and abuse of a corpse in the death of his girlfriend. 22-year-old Jasmine Pace was found in December of 2022 inside a suitcase along a road in Chattanooga. Her ankles were handcuffed and shackled to her right arm, according to reports from Local 3 News. A medical examiner determined she had been stabbed more than 60 times. Her body was found days after she was reported missing by her family. According to an affidavit, Pace's parents broke into the apartment of Pace's boyfriend, Jason Chen, after tracking her location on November 23rd. Her parents told police they found Pace's identification and credit cards, but there was no sign of Pace or Chen. People magazine reports that following days of pressure from her family, police finally executed a search warrant and found blood throughout Chen's apartment. Crime scene technicians also determined there were attempts to clean the alleged crime scene. An investigator noted, quote, a large volume of blood had been cleaned up and there were signs of a violent physical altercation. The affidavit also references surveillance video that appears to show Chen purchasing cleaning supplies from a Walgreens and driving Pace's vehicle. Chen's attorney said in opening statements that Chen did in fact kill Jasmine Pace, but that he should be convicted on a lesser charge, claiming Pace's death was a crime of passion. Due to the publicity of the case, a jury was brought into Chattanooga from Nashville. Chen faces life in prison if convicted. What's happening here? Well, this is one of those rare instances where you will see a defense try the strategy of admitting guilt, but only to a certain extent. And this type of strategy oftentimes is very high risk because you are implicating your client. You are implicating that the defendant is guilty of something, but it can also be high reward in the sense that it's hoping a jury might accept that degree of honesty, that degree of taking responsibility, and only convict your client of something that perhaps spares their life, that perhaps gives them an opportunity to see the light of day outside of a prison once again. But does it work in this instance? Well, we've got 60 stab wounds. 60 stab wounds. That is a real difficult pitch to make as a crime of passion, as a person so caught up in the heat of the moment that they took somebody else's life, somebody that they cared about, somebody that they were perhaps in love with. Then you have the cleaning up of the body and the hiding of the body, and all of this other stuff starts to lend itself towards premeditation. Remember, premeditation only takes a moment of time. Premeditation is not scheming and planning for days. Premeditation can be simply the making up of one's mind in a moment to decide to take someone else's life. Oftentimes, as a prosecutor, we would use the example of a person heading towards a traffic light. We've all done this. The light's green, and as you're approaching, it turns yellow. And in that moment, you make a decision. Am I going to stop? Or do I got other things I got to get to? Am I late for an appointment? Am I going to stomp on the gas and try to make it through that yellow light? In that moment, as quick as it is, we've thought about things. We've thought, are we late? We've thought, do we have other people in the car that we're concerned with their safety? We've thought about the traffic conditions. We've thought about even perhaps the time of day, everything in those few seconds, fractions of seconds, before we decide to press the brake or press the gas. That can be premeditation. That can be thinking about what you're doing. And I think there's an argument to be made here that somewhere in 60 stabs, 60 times of thrusting a knife into another person, are you making the decision to take that person's life? But here's another way to think about it. It's obviously overkill. It obviously did not take that many blows with a knife to take this poor young woman's life. Does that perhaps demonstrate, lends itself towards the arguments of a shattered psyche, of a person caught up in the heat of the moment, and a person in the heat of passion who has just lost their mind, triggered by some event, and done this incredible act of violence in that moment? Or is the reason that we're hearing about these arguments is because that's all that they have left? There is a rock solid case to tie this defendant to this crime. There's very little evidence, very little argument that could be made about self-defense. There's no alibi. There's no someone else did it. This is obvious that your client is guilty for this crime. And what are you left with? What other defense do you possibly have but this kind of throw yourself at the mercy of the jury? Say that he's responsible. Don't try to claim he wasn't there. Don't try some weak argument about burden of proof. Say your client's responsible. Take some responsibility for it and hope that they might show you some mercy when you make an argument to say, yes, but, yes, he took her life, but it was in the heat of passion, and don't find him guilty of premeditated murder. But what do you guys think? Do you think this carries the earmarks of heat of passion murder or a cold-blooded first-degree murder? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to take a moment to ask you to do one small thing, and that is, if you haven't already, please subscribe to this channel now. We want to continue to provide you with the highest quality content that we can, and the best way that we can do that is through your support. And don't forget to check out Courtroom Confidential, the podcast. Join our community on all major podcast platforms. Also making headlines, Judge Beverly Cannoni ruled on Monday that a dog bite expert for Karen Read's defense team can testify at Read's retrial later this year. The state had sought to keep Dr. Marie Russell, defense dog bite expert, who testified at Read's first trial, from testifying in the upcoming trial. She testified at a pair of recent hearings where the Norfolk County District Attorney's Office referred to what they called inconsistencies in her testimony. Quote, "Here, the recognition of dog bite wounds is not within the common knowledge of a layperson and requires expert testimony, and Dr. Russell is a qualified expert as to these topics," Judge Cannoni said in her ruling. Cannoni recognized that prosecutors were able to demonstrate during their cross-examination of Russell at the recent hearings that her, quote, "expertise primarily concerns the treatment, not the identification of dog bites, that her evaluation of the abrasions failed to consider all available information, that she has not compared the abrasions with the dentition or tooth arrangement of the German Shepherd in question, and that her opinion is inconsistent with findings that there was no canine DNA in the area of the victim's clothing near the abrasions. But she said those issues can be addressed by prosecutors when she takes the stand at the trial, citing Massachusetts court precedent that says judges don't determine whether to credit the expert's ultimate opinion. Sean Diddy Combs has been named a defendant in another lawsuit accusing him of sexual assault. In the complaint filed in New York, the plaintiff, only identified as Jane Doe, claims Combs raped her in 2000 when she was a 16-year-old high school student. This accuser alleges that she was working as a babysitter in an apartment building where Combs' unnamed romantic partner also lived when she encountered the music mogul and two other men who apparently worked for him. Combs asked the teen if she wanted a ride home repeatedly, the complaint alleges, before she eventually got in his car after refusing several times. The plaintiff first became alarmed when she was not dropped off at home. She claims she was then offered a drink to, quote, calm her down, which caused her to feel groggy and unsteady. The plaintiff alleges she was then taken to another location by the Bad Boy Records founder and his two employees, who are not named in the suit, before Combs raped her. Combs has been named as a defendant in more than 30 lawsuits accusing him of sexual misconduct. He's currently behind bars in Brooklyn as he awaits his trial on federal sex crime charges, which is scheduled for May. Donna Adelson's lawyers are seeking a change of venue ahead of her murder and conspiracy trial in June. Her attorneys, Jackie Fulford and Joshua Zellman, filed a motion claiming that the South Florida mother cannot receive a fair trial by jury in Leon County due to pretrial publicity in the case being so inflammatory, emotional, and pervasive that the Leon County jury pool is now tainted by preconceptions, bias, and prejudice towards Donna Adelson. The defense team added they were forced to file the motion sooner than originally intended after the clerk of court failed to seal the transcript of a September 6th hearing on the defendant's motion concerning the testimony of Donna Adelson's estranged son, Dr. Rob Adelson. During that September 6th hearing, the court ruled that Dr. Rob Adelson's opinion was inadmissible. Quote, "It is damaging enough that his son is called to testify against his mother," the defense wrote. Now, with this information about his inadmissible opinion out there, no one can unring that bell. Both Summit County prosecutors and the Kouri Richins defense team want to question potential jurors from Summit and Salt Lake counties in person, not via video conferencing. 3rd District Court Judge Richard Mrazek initially granted the request and said he would allow the jury pool to be drawn from both Salt Lake and Summit counties. He was later overruled by the district's presiding judge. On January 6th, the Utah Supreme Court agreed to hear an emergency appeal of the matter. No filing deadlines have been set for legal briefs, nor has a date been set for oral argument. The petition from attorneys asked the court to rule on the issues in February, with the murder trial set to begin April 28th. A ruling from justices to allow a jury pool from 2 counties could set a new precedent in Utah. The next pretrial hearing is January 23rd, when Mrazek is expected to decide which evidence will be admissible. Former neonatal nurse Erin Strotman, accused of injuring several babies at Henrico Doctors Hospital in Virginia, was denied bond on Monday after being charged on 1 count of felony child neglect and 1 count of felony malicious wounding on an infant in November of 2024. The charges stem from the discovery of multiple infants in the hospital's neonatal intensive care unit having suffered unexplained fractures. An investigation was opened after 3 babies were found with fractures in late November and December of 2024, injuries similar to those sustained by 4 infants in the summer of 2023. Surveillance footage from November 10th shows Strotman allegedly placing pressure and weight on a baby's legs and pushing the baby's legs backward to his head. All of the previously closed cases related to similar incidents in 2023 have been reported as part of the recent broader investigation, according to Newsweek. Before we get to what's on the docket for next week, I wanted to take a moment to thank you all for your support. The love from our growing community has been absolutely amazing. But I wanted to give a special shout out to Patty Podcast for their fantastic review on Apple Podcasts, as well as to our CC crew members, Dare, Stumble, and Boss Lady 325 for their thoughtful comments on YouTube. Please keep them coming. We absolutely love hearing from you. On the docket next week, OnlyFans model Courtney Clenny, charged in the fatal stabbing of her boyfriend, is expected to return to court on Tuesday, January 21, for a pretrial hearing. A hearing is set for Thursday, January 23rd, to address a request by Brian Koberger's defense team to throw out key evidence in the Idaho student murders case. Accused grief author Kouri Richins will be back in a Utah court for a pretrial hearing on Thursday, January 23rd, to take up the admissibility of key pieces of evidence in her quickly approaching murder trial. Matthew Nilo, a New Jersey lawyer accused in a series of Boston rapes from over 15 years ago, is expected to return to court on Friday, January 24th, for further status updates. And finally, this coming Monday, we are back with a new episode in our Courtroom Confidential Conversation series, where we interview Paul from the popular YouTube channel Reporting Live from My Sofa. Please join us live in the chat as we premiere this on Monday at 5 p.m. Pacific, 8 p.m. Eastern. And that is it for us this week, folks. I am your host, Joshua Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.